All right, we want to thank everybody for joining today's webinar with Anderson Advisors. And today we've got Clint Coons, our attorney specialist on real estate asset protection. And today we're going to talk about corporate compliance nightmares. My name is David Gass. I'm a entrepreneur, online marketing guy, and also just a person now in working with Clint and the rest of the guys here at Anderson Advisors and helping them out with several areas. So I'm excited about today's webinar, Clint. I think this is going to be fun, looking at one of the most fun areas of owning a business, corporate compliance, right?
Yeah, that's what gets me really interested about having a business. Filling
Yeah,
out
exactly.
paperwork.
Gotta love it. That was one of the things when I had my own business for about 10 years, and one of the things that I always was frustrated by was the amount of paperwork that it seemed like the attorneys were making us do. So why is it that attorneys just love paperwork?
Well, for most attorneys, they bill based upon the amount of paperwork they have you complete. So, from that standpoint, it's monetary. But really, the reason why attorneys want you to complete the paperwork, because as they say, the devil's in the details, is that so many people will go out there and start their own business as a sole proprietor, and there's no formality involved in that. And it's real easy to set up that type of business. But if you go down that road, of course, you have no protection. You have no benefits that come from running an actual business that's set up like a corporation or a limited liability company. So when the attorneys talk about the importance of paperwork, what they're saying is that you're now electing to take your business out of the sole proprietor realm and elevate it to a much higher level to gain some additional benefits. And in order to do that, it's going to take some effort on your part.
Yeah, good point. That's certainly the way that we as business owners should be looking at it. So let me ask you this, is because I've heard a lot, and the title of this webinar is about the nightmares, and I've heard a lot about reasons why I need to make sure that I'm maintaining the records and maintaining those the paperwork that you just talked about, and it's because of the nightmares that could potentially happen to us, piercing of that veil, things like that. So give us an example or two of things and reasons why we should be paying attention to this to begin with.
Well, I like to give an example during my events about an individual. This is a client of mine, actually, that did not heed the advice that she was given to run her business in a specific manner. So what we did for this person is we set up a number of limited liability companies for her, and each of those LLCs was to own a particular piece of property. In addition to that, we created a corporation to manage it. So she had all of the requisite paperwork that's required to have a business established. Now, when we turned that business over to her to go out and run, I did it with very specific instructions. And that was, if your corporation's going to manage your LLCs, you need to have a management agreement between the corporation and the LLC to give validation to that business relationship that you intend to create there. The second thing, as I stated, is that remember, these are businesses here, and businesses are run in a specific way. One thing in particular is a business needs to have a bank account. And she was shocked that she had to create 7 bank accounts. And when she left my office, I guess that was disturbing to her, so she went and talked to her CPA. And of course, this is a problem a lot of people have, is you have too many different professionals in the mix and they're not communicating with one another. She didn't tell me she was going to go talk to her CPA and bounce my ideas off of him. And when she did confront her CPA on this particular issue, he said, "Oh, you don't need a bunch of bank accounts. We can run everything through the corporate account. Just have one account. And for tax and reporting purposes, I will treat everything as if it went to the appropriate limited liability company. So I'll make it much easier for you to conduct your business." She adopted that strategy without consulting me, and everything ran just fine. And I tell people that a lot, that you can set up your business, you don't have to do anything, and until you get sued or your entity is stress tested, you're not going to know what you've done wrong along the way. I mean, just as an aside, I met this other guy not too long ago in North Carolina who told me, "Yep, Clint, I've got 13 limited liability companies set up, and I've done it all by myself. They're single member. I don't have to do anything. I don't need an operating agreement because the state doesn't require it." And I said, "All right, well, I'm not even going to address that issue, but let me just look at how you filed your entities." And sure enough, when he pulls out the articles of organization that he used to create his entities, he just checked this box that said he is going to be personally liable for all the obligations of the LLC. And I confronted him on this. I said, why did you do this? And his initial response was, well, it's a box. I figured it needed to be checked. And I said, this is an example where you're not understanding how these entities work and why we want you to complete the documents in a certain manner. And unfortunately, for going back to my client, the bank accounts were to be established so that she ran her business in a specific manner, gave validity to the overall structure. Well, when her corporation was sued about 4 years after everything was set up and a judgment was entered against her corporation for $120,000, my client sought to discharge that judgment by bankrupting out her corporation. Basically thought she could walk away from it because the corporation had no assets, it would take the fall, and her LLCs would be protected because they're separate boxes. Well, her problem, unfortunately, was that the plaintiff was not going to accept no for an answer. It was an aggressive plaintiff, and they went after her LLCs with this $120,000 judgment, and they argued to the court that the business entities themselves, these limited liability companies, lacked a separate and distinct business identity from the corporation, that they should be looked at as one common enterprise. And the argument they used to get the judge to agree with their proposition was that the LLCs did not have separate bank accounts, and therefore, how do you conduct business inside of an entity if you don't even set up a bank account for it, because no money ever ran through the LLCs? And the judge said, you're right. He goes, this is basically one common enterprise with some different names on it, therefore I'm going to allow that judgment to attach to every single entity. Now, this isn't the example where you've pierced the corporate veil from the standpoint and you went after the individual. But keep in mind that veil piercing is not just about breaking down the company so you can get after the owners. It's also about breaking through the barriers of the entities themselves, the separate entities you create, in order to get after the assets of these various units. So it takes on many different personas depending on the argument that is made by the plaintiff.
Yeah, it's a great point, because that's one of the things that I've heard over the years is that whole idea of piercing the corporate veil and going after you individually. But as we structure these entities with clients in the real estate area, they have multiple entities in many cases. So people are going to want to go after and get into those entities that have assets in them. So it makes sense as to why they would even think about doing it that way. So when it comes to how to avoid nightmares like that, there's obviously some things that we can look at as business owners, real estate investors, and that to make sure that we avoid nightmares, making sure that people don't go in and pierce that veil to get into our entities, get assets that really they shouldn't be going after. So some things, you mentioned one, which is having separate bank accounts for each of these types of entities. What are some other things that we should be looking at in order to avoid that nightmare, so that if we're in front of a judge and they look at that, what are they looking for?
Well, in order to determine what they're looking for, we don't look to the statute, nor do we look to case law to say this is what we need to have. In fact, it's just quite the opposite. What we do is we look at case law and say, what does the court look for in order to allow a plaintiff to pierce your corporate veil? And typically what we're looking at initially is fraud. I mean, one of the things that the court is most concerned about when it comes to piercing a corporate veil is they're going to ask, did the individual who owns the business perpetuate any fraud? Because this is an equitable remedy. And what that means is you give a lot of discretion to the court to fashion a remedy for the plaintiff if they feel that certain things have transpired that we want to prevent wrongdoing, and then we're going to allow the plaintiff to pierce the company and go after the actual owners who were, taking part in this wrongdoing. So some of the things that they typically look at in determining whether or not there is a veil-piercing argument here, things that you should do to avoid the nightmare, of course, is intermingling business assets with personal assets, keeping a distinct line. Many times I get this question, well, Clint, are you going to ask, you tell me then that I cannot spend personal assets for the benefit of my business? And in fact, you can do that. The problem we run into with veil piercing is when people use their business for personal benefits. That is, for example, let's say I go into the grocery store and I'm going to buy $200 worth of groceries at Costco. It's all for my personal benefit. There's no business purpose behind this purchase, and I routinely use my business Amex. Or when I'm uh, going out and I want to buy say I'm going to buy my kid a video game machine or something for his birthday, you whip out the business Amex. And so what I'm always doing is using business assets for personal benefit. That's a real problem because you're blurring the distinction between your business and what is personal. Now, on the flip side of that, it is okay for you to utilize your personal credit card to make business expenditures because here you're benefiting the business. And it may seem like you're splitting hairs, but we're most concerned with piercing the corporate veil. The situation we're looking at is when is the business being used as your alter ego to benefit you personally, rather than you doing things on behalf of your business. It's pretty common for people to have, or business owners maybe, to have their employees spend money on behalf of the business, then they reimburse them. So one of the things you can do is you can spend money on behalf of your business, but you still need to then keep track of that. And so how do you avoid the nightmares? Keep track of the business expenditures you make. Make sure that you're reimbursing yourself. We often tell people to have an accountable plan set up with forms that they, of course, would fill out seeking the reimbursement from their business, so they're papering their file. And this is not just from the litigation standpoint of having somebody sue you and look to get after you individually by breaking down your corporation. There's also from an audit standpoint, that if you're audited and you haven't done the necessary things to maintain your business in the right manner, then you give the IRS the option then to ignore the corporate form, which is many times is providing you tax benefits, and instead assess you with all of that income and disregard the deductions you were taking because now we've taken the corporate form and decided it didn't exist from the outset. So avoiding these mistakes is, again, looking at the steps the court or the issues the court will typically focus on, such as, do you have corporate records? I mean, did you actually put together an operating agreement? The example I gave you, the guy I met in North Carolina, he never had an operating agreement. All these LLCs and not one single operating agreement. All he has are the articles of organization and a certificate of formation. And for him, that was sufficient in order to run his business because he was able to open up a bank account with those two pieces of paper, and he figured he didn't need it anymore. He didn't want to go to the trouble to do it. Other things that you should do to avoid the nightmare would be to have annual meetings. I mean, know what is required of you. There's always the bare minimum that's required under statute that you must participate in. For corporations, you have to have at least one meeting a year. We recommend you have at least 3 to 4 meetings a year, and you document those. Just because, say, take an LLC, it's not required to have annual meetings. You have to look at it from the eyes of the judge. If you're arguing a case and the judge is not accustomed to dealing with corporate issues, or say a limited liability company looks at the LLC the same as a corporation, which is not uncommon. You listen to many legal or proceedings, and many times judges will call a limited liability company a limited liability corporation because they view them as the same type of entity, when in reality they're very different. In an LLC, you're not required to have meetings. But if it's an active business and you're looking for protections, well, I think you probably should have annual meetings, which brings up this paperwork slide that you've shown now, that if I'm running an active business, even though it's not a corporation, there's certain things that you expect businesses to do, namely document decisions. In fact, I myself have been in that situation. A limited liability company, 4 partners. We decide to remove one of the partners from this joint venture we had gone into because this one partner wasn't doing what we had requested of him. Just wasn't participating, wasn't bringing any value to the partnership, but wanted to sit back and take money. So we removed him. Now, under the statute, I'm not required to go in and have meeting minutes. But when I went into a court of law, because this individual brought a lawsuit against our limited liability company, well, the first thing the judge asked to see was, let me see your meeting minutes of the meeting where you decided to remove him. Let me see the meeting minutes of the meeting you had with him. Let me see the resolution removing him. So immediately the judge started asking for paperwork that is technically not required under law to be provided, because they look at the LLC like a corporation, and these types of things are set up, unfortunately, to be paperwork generators.
Yeah, and that's two things that are very interesting. Is that there was a case I read recently about a couple. Well, actually, it was a couple years ago, but a couple out of New York who was doing something like what you were talking about, which is taking a bunch of uh, money through their entities, but they were taking like a $30,000 salary, but yet they were living in these big high rises in these huge apartments in New York, and so the IRS obviously audited them and went after them because of that. But what they were doing is just expensing every single thing possible through their entities, right, and not keeping any paperwork, or paperwork and documenting any of it. The other thing that's interesting is that I hear all the time from people in this area and why they set up an LLC. Because I ask, why did you choose an LLC over or a different type of entity? And I don't have to do any paperwork. And so the answer to that, from what I'm understanding you're saying, Clint, is that there is paperwork. Yeah, it may not be required by the state statutes, but when it comes to the court of law and when it comes to taxes and the IRS, they're going to be asking for it, right?
Correct, because what you do when you draft paperwork is that you establish intent. If if I have a business that I've set up an LLC to take advantage of the liability protections that the LLC provides. I mean, that's one of the reasons why we're doing it. We're also setting it up, let's say, to receive certain tax benefits. Maybe we have it taxed like a corporation. Whatever your motivation is, how do you establish that your true intent behind creating this entity was to actually conduct business? Well, number one, you show that intent by drafting an operating agreement. You show that intent by actually holding meetings, putting together resolutions whenever you want to make a decision that affects the overall nature of the company. You show it by having good books and records. I mean, a lot of people set up the LLCs or their corporations. Not only are they not put together any minutes or resolutions, but they won't have any books to go along with it, such as putting things down in QuickBooks so you can provide a profit and loss statement, or you can provide a balance sheet to someone upon request. I mean, these are things anyways that you're going to learn eventually with your business, because if you want to go out and get a loan, the bank is going to request this information of you, and you're going to have to go and create it and provide it to them. I just refinanced one of my commercial properties today. I had the closing, and I was down at the title company, and one of the things they asked me to bring with me was the lease agreements between the building and the tenants. They wanted to see the resolution for the LLC authorizing it to enter into this transaction to refinance a property, and they wanted to see the meeting minutes of the members in the LLC electing to go through with this transaction. So here's an example of a bank requesting it.
Yeah, so again, the idea of not needing LLC documentation is just kind of a farce, if you will, out there. So when it comes to, well, here, let me skip back and go to a housekeeping thing. For those that are on the call now, and I usually wait until the majority of people are now on our call, so we thank everybody from around the country for joining us today. And if you have questions, for those of you that are used to some of our old style webinars, we used a different format. So this one, if you have questions, just scroll down to the bottom of the page and you'll see a section down there. You're just going to type into it and hit submit comment, and then you can ask the questions, and we'll get to those right towards the end of this webinar as well. So I just wanted to throw that out there. Next thing is just when it comes to looking at setting up, if you've got, I don't know, 6 or 7 different entities, what are some steps that people should be looking at when it comes to getting all of those entities into compliance? Or even if they just have 1 or 2, there's some steps that we should be taking and thinking about when it comes to looking at it. And what I mean by this is that if I'm operating my business on a daily basis, what are things that are triggers for me to go, oh gosh, I really should go create a resolution? Because there's times where people have asked me over the years, well, do I need a resolution for going and setting up a bank account? Okay, yeah, but do I need a resolution because I hired somebody, right? So there's a certain spot at which you don't need to spend that much time creating the documents, right? And sometimes you do.
Correct. Whenever in doubt, create a document is how I often was what I often tell people. If you're unsure, it never hurts to have more documentation. But generally speaking, that if I created a business to engage in the buying and selling of property, so that is part of my everyday business purpose and the transactions I engage in on a daily basis. Every time I want to buy a house, I'm not going to have a resolution because that's part of running my business. That's what my business was set up to do. Now, if I set up a company to buy and hold property, and so its intent from the outset was buy property, hold it for long-term investing, but all of a sudden now I want to start buying, rehabbing, and selling. So I'm starting to flip. Now I'm operating that company outside its initial scope, what is done on a day-to-day basis. So whenever you look at your business, you have to ask yourself, okay, is this common practice within my company to engage in this particular activity? If it is common practice, it's generally not going to require you to provide any additional documentation. But if it's outside the core of your company, then you will have to document it, and you need to have a resolution to do it because it's not something that is going to be typically handled by the officers of the company because they're not empowered to make those types of decisions. So what you talked about, benefit plans. If you decide you want to adopt a medical reimbursement plan or adopt a pension plan, you're most definitely going to have to file a resolution or prepare a resolution to do it because that's not part of your business. You're not in the business of providing pension plans to people. So for you to adopt one, you have to have a resolution because it's outside the core concept of what your business was created for. So I always put it in those contexts when everybody asks me, do they need a resolution for this or that? Say, is it part of your business? Another one would be a car. Let's say you decide to lease a car through your business. Well, your business is not about leasing cars, most likely. Let's say that your business was set up for real estate investing. So then you need a resolution to lease that car, most definitely.
Got it. Yeah, that makes sense. I mean, so for example, if somebody's hiring a lot of staff, they're not necessarily going to write a resolution for each staff member, but if they're hiring a new president of the company, that's not something you do every day, right?
Correct. So in a situation like that where you're elevating somebody to a much higher position, then you're going to want to adopt a resolution. Because, in a corporation, for instance, that type of decision is made by the board of directors. The everyday office personnel are not empowered to appoint a president of a company. So the directors, the way they communicate their desires is through resolutions in a corporation. Whereas if you're going to hire a new administrative assistant, directors aren't going to involve themselves with that. That's just part about running the day-to-day business. So you don't need the resolutions in that context.
Got it. And then when it comes to capitalizing the business overall, initially, I know there's some states that require a certain amount of capital, some that don't, and I've heard that initially putting that money into the business and capitalizing it is one of the things that the courts can look at when it comes to uh, piercing the veil. So is there anything that we should be looking at when we're setting up the compliance pieces and looking at, okay, let's create a resolution for the amount of capital we put into the business or a certain amount that we should be looking at when we first started? Is there any kind of set rule there, or is it pretty open-ended?
Well, it's open-ended to a point. I mean, you can create a business with $50. There's no actual requirement that you put in hundreds of thousands of dollars to create the business. But one of the things that someone might look at is if I created a business, I'm going to just use real estate because it's an easy one. Let's say I created a business to buy real estate. Now, in order for me to purchase this real estate, I go out and I have one of my other entities loan 110% of the purchase value, so then I've also covered some of the rehab costs, and I fully protect my interest in that loan by filing a deed of trust against the property. Now, I put in only $50 to this venture, so assume that somebody falls off a ladder, they're hurt, and they sue the LLC. An argument a plaintiff might make is that you created a corporation, you had no skin in the game, or an LLC, whatever it is you created to flip properties. You had no skin in this game of any substantial value. All of the assets were borrowed. So one of the arguments they use is that your corporation was too thinly capitalized for the type of activity that it was engaging in, so you had no recovery left for anybody that was injured. Now, one way we protect ourselves in that situation is by obtaining insurance. And many people, unfortunately, believe that if you've provided yourself with all this asset protection, you can dispense with any type of insurance. But in fact, if you were sued, one of the arguments a person would make is if you didn't have enough insurance to cover your foreseeable risk of loss is what they use. So you have to carry a reasonable amount of insurance to cover your foreseeable risk of loss for whatever type of adventure you're engaging in. Now, if I had an LLC set up to hold my brokerage account, well, I don't need any insurance there, and obviously it's adequately capitalized. But if I had an LLC set up to hold rental property, well, I should have some form of insurance on that property. I just can't go without any insurance on the property and say, well, if the tenants hurt themselves because of my place burns down as a result of some faulty wiring, well, they're on their loan. Tough luck. So you have to be a little careful there on looking at the activity of the business itself and determining, do you need to put in adequate insurance, or how much capital should you actually put into that company to get it started as seed capital?
Got it. That's good. So a couple of people have asked questions here, so I'm going to go through a few of these questions and then talk to you a little bit about how people can actually get some of the resolutions, meaning minutes, things done that they need to get done. So start off, the first question was regarding 501c3s, and just we have a 501c3, and are there any advantages to putting the real property into its own LLC?
Well, absolutely there would be with a 501c3, because for those of you who are not familiar with it, it's a nonprofit organization. If you bought property directly in the 501c3, then if something happens with the tenant on the property, they would sue the 501 and any of its assets would then be at risk. So to provide protection for the assets of the 501 and its overall general nature, you would set up a limited liability company that's owned 100% by the 501c3.
Got it. And as part of that, are they 501c3s also required to maintain the same type of resolutions meeting minutes
Correct.
on an annual basis too?
501c3 is typically a corporation, so you're still going to have to do the same thing.
Okay. And second question, do I need a resolution to invest from my QRP from LLC, i.e. trust deed investing?
Well, if the LLC was set up for trust deed investing initially, then the LLC wouldn't need to have a resolution to go out and buy trust deeds. But the qualified retirement plan itself, it's not an entity that would require a resolution because the QRP is a trust. So in that case, the QRP would not need to have a resolution to set up or invest in the LLC. So you'd be fine with that particular issue.
Got it. Do your meeting minutes and resolutions need to be notarized?
No, they do not need to be notarized, but here's something that you want to keep in mind. Whenever you're dealing with your corporation or your LLC for your personal benefit, when we're talking about the extension of credit, for instance, that is when you're loaning yourself money, it is a good idea, and I'm telling you this from firsthand experience, to have those types of documents notarized to establish the date that you actually took the loan from the company. I ran into this problem. This was from an audit standpoint. I was audited 8 or 9 years ago, and the IRS looked at my loan and they said it was disguised compensation. I told them, no, this was an actual loan. I had prepared these minutes and this resolution. And they said, well, how do we know you just didn't prepare it prior to walking into this meeting? We don't believe it. We think that you've gone back and recreated paperwork because you didn't want to have to recognize this money you took out of your company as a salary or as a bonus. Instead, you're trying to recharacterize it as a loan. Well, they disregarded the fact that I've already actually repaid part of it with interest. And they told me in no uncertain terms that, hey, listen, if you want to fight us on this, you may win, but it's going to cost you more than it will just to pay the taxes, and we won't assess any penalties, and we'll just go away. And I ended up just paying it, just so I can move on with my business. Now, had I had that document notarized, that would have totally removed their argument off the table, because then there would be no doubt that I had prepared that document when I initially took out the loan because of that notary stamp. And now whenever I engage in similar transactions with my own company where there could be construed to be a personal benefit, I do notarize them.
Hmm. That's very interesting. I'd never heard of that, so that's great. Um, Next question. A fairly new corporation. I have a fairly new corporation through Anderson Advisors and don't fully understand the language of the bylaws. Do you guys have classes or training on the bylaws, keeping them in line?
Yes, actually, we do. That's funny that question would come up because we have an event coming up in Dallas next weekend, which we call it our Inc. U, and we're actually going to be changing that name starting next year and changing the event somewhat. But at those events that we hold periodically throughout the year, we go through your bylaws, your annual meeting minutes, showing you how to prepare them and explaining to you the benefit and the intent behind creating the language that's put in there. We haven't done a webinar on it yet, but we do it at our live events.
Great. Next question. We have a single person. This is a little long, so forgive me. I haven't read the whole thing. We have a single person LLC that holds real estate, and our C corp is the GM, general manager. Since corporation does all management, all decisions made. RE. I don't know if they mistyped it. The LLC are documented in a C corp meetings with appropriate resolutions. Do we also need to do meetings and duplicate resolutions for the LLC?
Well, in that particular case, no, you would not, unless the LLC itself was engaging in some activity outside its ordinary course of business, for instance, then you would have to have an LLC resolution. If the LLC is engaged in an active trade or business outside of just investing, then you would want to have some meeting minutes with regard to that LLC and carrying on its natural activities, just to paper your file to show that the intent is still there to treat it as an active business, and the members or the i.e. the manager are documenting that. So it depends on the nature of the activity of the LLC. Everything you've mentioned about regarding the corporation is proper, and you're doing or engaging in the right activity there.
Great. The next question, I have a corporation to manage assets, a brokerage account held by an LLP. Does LLP need the same business management care, having bank account as I
No.
issue checks and annual meetings?
The limited partnership or LLP is not going to need to have the and I mean, I assume they meant limited partnership, that the corporation is set up to manage an LP. The limited partnership will need a bank account or some type of form to distribute proceeds, some type of account. If it's a brokerage account, that suffices. You don't need to have a bank account. The problem you run into is whenever you do not have any type of financial account inside of your company, then it's hard to justify how that business could actually conduct business because it can't receive any revenue from whatever type of source of assets that it has inside of there that were set up to either be held for investments or generate business income.
Great. Next question. I'm not sure I understand this one. It's from Ed. A S member of LLC, are they exempt from signing non-disclosure agreement? Do you understand that?
Maybe a single member of an LLC, are
Oh,
they exempt from signing a non-disclosure agreement? Well, it really depends on who's requiring it of you. If you're dealing with a third party and they want you to sign a non-disclosure agreement, they're probably going to require that of the LLC and the individual members and or managers. So, you really don't have an option here when it comes to non-disclosures because the party requesting it is going to make the demand upon you if you want to receive that information.
got it. Will INCU seminars be held in Sacramento, California, by any chance?
That's up to you, David.
Yeah, we're working on places where we're going to hold them next year. We'll let you know. Next one. What about this is the last one? Oh no, we got two more. So what about setting up LLCs for each property? The cost of setting up in the state. What I'm planning is quite expensive. Setting up a foreign entity is as costly. Do I need to incorporate in the state I'm doing the work in? A
Well,
couple questions.
yeah. So here's something to keep in mind. So let's take this back to compliance. Now, when we talk about piercing the corporate veil, If you set up an entity in a state, or corporation, for instance, in a state like Nevada, and you then take that entity and you register it to conduct business in California, well, many times people ask, what is the benefit in doing that? Because all of the anonymity and the tax benefits of Nevada, that falls off as soon as you go into California. That is, you can no longer hide your ownership in the, I mean, not ownership, your position in the company, because you have to disclose it to California. Any revenue generated in California is taxable in California. You don't get to take advantage of what they call tax-free Nevada. And the third thing is, of course, that you have to register there because you're conducting your business there. So why would somebody want to pay California and Nevada if they're doing a lot of business in California? Well, from a piercing the veil standpoint, if somebody wanted to come after your corporation and pierce the veil, one way they would do it is they could argue that the directors, which would be you, that you engaged in some type of activity that allows them to break through the veil. And they want to oppose a reasonable man standard upon you, meaning that we look at your actions in light of what somebody else might have done in a similar situation. And so you say, would a reasonable man in this situation have made the same decisions? And so you're held to this standard that the jury comes up with of what they think is reasonable. Now, if that's a Nevada corporation, it's a slightly different standard. And so the court would have to instruct the jury that it's not a reasonable man standard here. What you have to do is you have to look at whether or not the person who made that decision, knowing everything that they know and given their background, is it reasonable for them to make the decision they made? Now, so are we splitting hairs here? No, this is a distinct difference between the first standard that California would apply if it was just a California company and the standard that Nevada applies. Because Nevada says, hey, everybody's different and we come from different backgrounds. So you can't assume that what Joe thinks is reasonable based upon his experiences is going to be reasonable to Ted. And so you have to look at Ted's experiences and see, based upon his limited information, his limited experience, does that seem reasonable at the time? And if the answer to that is yes, then it defeats the argument. So compliance in a situation like this, where do you set up your entity, could come into play because the court must utilize the jurisdiction where you were incorporated in determining whether or not a veil-piercing argument will fail or will stand on its merits. And so states like Nevada are very attractive for people because they have a much higher standard in order to pierce the veil. The courts there, or the statutes, are drafted in a way that give business owners greater latitude in the decisions they make. So when you're deciding where you want to set up an entity, that's part of what goes into the process. Yes, some states are more expensive and you can choose one versus the other for asset protection purposes because you realize you're paying for that when you go with a more expensive state. It's hard for me to answer this question in detail without having more actually details as to what you're trying to set up. And that's why for this person, I would recommend they call in and get a free consultation.
Sounds good. So there's a few more questions here, but before that, I mean, some of the questions are getting into do you guys actually do the compliance for us? And so what I want to do is just briefly describe the services that we do offer for our clients that does describe in detail where we actually work with you. So if you don't want to sit down and do all those meeting minutes and the resolutions on your own, we have a team here that actually does do that for you. And there's 3 different ways that you can work with us when it comes to that. One is called the Corporate Assistance Program, which actually includes a level of bookkeeping for you as well with that. So what we're doing there is assisting you with keeping the bookkeeping and the meeting minutes and resolutions in place. It's a $1,200 per year program. It has up to 2 hours of monthly bookkeeping and includes up to 3 entities that you can have meeting minutes and resolutions done for you. So if you've got 2 or 3 entities and one that you need some basic bookkeeping for, the corporate assistance program is the one that you're going to want to look at. The other is the corporate concierge, which is $695 per year, and that includes meeting minutes and resolutions. And we do those as often as you need them. For the most part, we're sending you out a quarterly questionnaire, just making sure that if there's anything that you need resolutions or meeting minutes done for, that's what our team will do for you. Again, up to 3 different entities. And then the third one is our corporate headquarters program, where we actually have your verifiable address here in Nevada with the phone answering, and up to 3 entities for the minutes and resolutions. So I'll leave that on the screen while we answer just 2 more questions. But if you do have an interest in any one of those services and you aren't currently running your business through that, there is a form right below the video that we've put in there. So wait until we're done before you hit contact me. But you just put your information in there, which program you're interested in, hit contact me, and one of our representatives will call you and just talk to you about what that program is and just determine if it's the right fit for you or not.
You
So
know, David, if I could mention something about, like the corporate headquarters program for Boss Nexus, people often ask, do I really need that? Well, if you set up a business in another state, you need to have a physical presence there where actual services are being performed, activities are taking place. And one of the things that we do through our Nevada office is provide the actual services like you see up here, where you have somebody, a legal assistant, preparing meetings for your company, resolutions. We have bookkeepers there doing the books for it. There's a recent case out of Massachusetts last month where the veil of a company was pierced because the individual, this was a single member LLC case, so these seemed to get a lot of attention. This guy, he didn't have an operating agreement. All he had was a certificate of formation for his company. He ran his business out of his house and his car. He had no bookkeeping records. They had no tax records or returns because it was single member LLC. And so this is a problem you have with judges. They just didn't understand it. The single member LLC, you're not going to have a tax return because it's not required to file one. He didn't have a checkbook or records of payments. I mean, because he just ran everything, on the fly. So you look at this is intuitive as to what do the courts look at. Business offices, those are important. Having a physical office, making sure that you have the bank accounts as we talked about before, that you have good bookkeeping records so you can show somebody, here's how much money I'm making, that I'm keeping track of what's coming in and what's going out, rather than just saying, well, as long as I have money in the account, I know I can continue to conduct my business. You have to do more than that.
got it. Very good. So we'll do 2 more questions and then we'll wrap up. So the next question is, and I'll shorten his question, which is basically, if I haven't done meeting minutes and resolutions for the past 5 years, should I do them now or am I out of luck?
If you haven't done it, you should do it now. That's fine. Routinely we run into this for people where we'll go back and recreate those minutes. A lot of it is people have actually created them. They don't realize it because they've made decisions. They just haven't documented those decisions. And so now's the perfect time to go back and get those minutes created where you've documented the decisions you made in the past, so then your folder's all taken care of and you've papered it properly.
Perfect. And then the last question: if a limited partnership runs out of money and the general partner makes capital contributions into the limited partnership, can reestablish income, how long can general partner continue doing this? Did that make sense?
I think so. So you said if the limited partnership runs out of the money and the general partner makes a capital contribution to the LP, how long can the GP continue doing this? Well, they can do it as long as they want, but the contribution should come not only from the GP but also from the limited partners at the same time. So you want both making contributions. So if a general partnership has a 10% interest in a limited partnership and you're going to move in $100 and a 90% is held by the limited partners, they should be moving in $900, so you keep your capital accounts in balance.
Got it. And then, so one last question before we end, which is just, I'm behind on my fees to Nevada for my LLC. Is there a grace period, and am I out of compliance when I'm in default status?
Well, no, actually you're not. There's been a number of cases on this where somebody was behind on their fees and they were still continuing to conduct their business as an LLC, and they were sued, and the plaintiff tried to pierce the LLC on that particular argument alone. And courts are pretty lenient there, and all they require is that you go through and bring your LLC back into compliance with the state. In fact, that's just one small factor. They're going to look at the other factors as well on how you conduct your business that we've been going through. So the answer is that you're okay, but is there a grace period with the state before they revoke your company Well, that really depends. I mean, most states you can go 60, maybe 90 days, and if you don't pay the fee to Nevada, then your company goes into revoke status, and then technically you could be in a problem where you no longer have the asset protection.
Sounds good. All right, Clint, thank you so much for making a subject that's not always fun for everybody. Everybody stayed on, so that's great. And any last words before we end?
No, I just hope that everybody, they got something out of this and they understand that there is some importance there that you have to take care of when it comes to running your business. And it does require a little work. It's not the most exciting stuff. Everybody likes to make money, but you have to sometimes go back and look at what it takes to do that from a legal standpoint and tax compliance standpoint. And that's hopefully what we conveyed tonight.
Sounds good. And for those that still are asking questions, we'll get to those. We'll just type in the answers for you. And I want to thank everybody again. If you do have interest in any of those particular services listed up here, just go ahead and fill out the form there below. And thank you again for joining today's call.
Thanks.